The destruction of privacy in America looms so large that I simply haven't gotten it out of my mind since reading a quite compelling new Random House book on the subject, titled The Unwanted Gaze. Jeffrey Rosen, its author and my guest today, is legal affairs editor of the New Republic magazine and an associate professor at the George Washington Law School in the nation's capital. Well, as you might guess, in his provocative analysis of the destruction of privacy in America, Kenneth Starr and Monica Lewinsky play an important introductory role. Indeed, Professor Rosen writes that one of the virtues of the Starr investigation was to remind Americans how little our legal system cares about privacy today and how much more robustly intimate secrets were protected in the not-so-distant past. The subpoenas issued by Starr, he reminds us, were perfectly legal, but for most of American history, many of them would have been suppressed as clear violations of the Fourth Amendment to the Constitution, which declares that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Well, what happened to erode those principles, and why, are, of course, the questions that Jeffrey Rosen then asks. And I want him to share his answers with us today. Just why have constitutional protections for private papers, and now email, and even semen stains, evaporated, as he suggests, during the past few decades? Why does there seem now to be so little public concern for privacy? Professor Rosen, I want to ask, what's happened?
It's a fascinating and complicated and difficult story. And the place that I like to begin, I'm so glad that you mentioned the example of diaries and email, because it was the search of her undeleted email that Monica Lewinsky found most invasive about the investigation, and the moment when prosecutors retrieved from the hard drive of her home computer the unsent love letters that she had drafted but never sent to the president. And she says in her underappreciated memoir, this seemed like such a violation. How is it possible that in America prosecutors could subpoena a diary? I set out to answer that question, and I go back to the time that the Fourth Amendment to the Constitution was framed. You read it. It prohibits unreasonable searches and seizures. And if you were to ask the framers of the Constitution, what is the paradigmatic example of an unreasonable search, they would have cited the search of a private diary. And there's a wonderful story of John Wilkes, the roguish English patriot, the Bob Packwood of his day, who wrote salacious pamphlets making fun of King George III's mother. And King George dispatched his Ken Starr figure, Lord Halifax, to break into Wilkes's desk drawer, seize his private diaries, and tried to cart him off to the Tower. And Wilkes objected. My most intimate secrets have been exposed to the world. And he sued the king in trespass. In the 18th century, it was private property protections that guaranteed privacy. You had to break into someone's house to seize his diaries. And Wilkes won a tremendous verdict, £1,000, a ruinous amount in its day. And this case was cited by the colonists, from John Hancock to John Adams, as a great victory for privacy. They named towns and infants after Wilkes. Wilkes Barre, Pennsylvania. This was very much on the minds of the colonists. So how was it possible that we moved from John Wilkes to Bob Packwood to Monica Lewinsky? Part of the story is a constitutional one, and what's so remarkable about it is how recently these protections were eroded. It was during the 1970s and 80s that the Supreme Court held that when you surrender information for one purpose, you abandon all expectation that it will be kept private for another purpose. And this had the rather tautological effect of allowing companies and employers and prosecutors to lower our expectations of privacy in a way that then gives them more discretion to search. So in other words, if the Fourth Amendment now turns on what people's expectations are, subjective expectations that society is prepared to accept as reasonable, this is the test that Justice Harlan gave us, by telling you in advance that your email may be monitored, employers can lower your expectations of privacy in a way that gives you discretion to monitor email. So this is it's a terribly important but little noticed story. When Bob Packwood objected that his diaries had been searched, his case was summarily dismissed. The courts sniffed it away, the public laughed at him. But I actually have some sympathy for Packwood, as I do for Wilkes, as I do for Monica, because the notion that there's no intimate sanctum where we can record our thoughts without fear of state scrutiny is one that the framers of the Constitution would have found chilling and unrecognizable.
Okay, the change occurred. Why? Something must have presumed to have been gained by losing that privacy.
I think the legal story, which is a complicated one, turns a lot on the difficulty of keeping a regulatory state going in a world in which we have robust protections for private papers. As late as 1890, the Supreme Court held that you couldn't even subpoena someone's business papers because that would be too much of an invasion, both of his Fourth Amendment rights against unreasonable searches and seizures and his Fifth Amendment rights against compelled self-incrimination. The idea was that even receipts for plate glass were somehow an intimate reflection of your mind that would incriminate you. Think of how robust those protections were just 100 years ago. It's a lovely notion. Justice Brandeis, the greatest advocate of privacy, the hero of my book is Justice Brandeis. He called the Boyd case a decision which will live as long as civil liberty is remembered. The difficulty was that it was hard to enforce tax laws and regulatory laws and environmental laws in a world where you could really keep all of your business papers separate. So in an effort to keep the New Deal going, the Supreme Court held in the Progressive era that a subpoena wasn't even a search. To compel someone to turn over a paper wasn't really searching them, and that was part of the story. So part of the erosion of privacy is legal, but the more important aspect of the story, I think, is cultural and technological. So should we talk a little bit about that?
Indeed, indeed. Why do you say it?
In a world where thinking and reading...
Wait a minute. Let me stop you for a moment.
Please.
The technological and cultural, which you will elaborate upon.
Yes.
Do you believe that the changes in the law that took place would not have taken place without those technological and cultural changes?
Law is deeply dependent on social norms, and when we see the subjective aspect of the legal test for privacy, what subjective expectations of privacy is society prepared to accept as reasonable? This presumes that we as a society care about privacy, and it's not really clear that we do. So this is how the technological and cultural aspects...
Now, what are the indications that we as a people do not care?
Think of all the ways that we live our lives as if they were not virtually exposed. On the internet, when you pause to think about it, all of our intimate thoughts, reading and writing and sex and gossip, are monitored and recorded and can be wrenched out of context at a later time by those who don't know us.
But you're making the assumption that we, most of us, who innocently use the internet, who innocently send back and forth email, make the same assumptions about that email that we would make about the U.S. Postal Service.
One doesn't want to generalize too broadly, because, of course, one of the interesting parts of the story is that people have deeply conflicting intuitions about privacy. This is not an age of where communal norms of reticence and restraint, the ones that prevailed in Brandeis's day, are widely accepted. It's an age of Jenny-cam, where people, as we learned from the New York Times Magazine, put cameras in their bathrooms of Fergie and of Geraldo, and there's some people who don't particularly value privacy. But when I talk about technological changes, I just want to say that I think the reason that privacy is contested now is that we haven't yet accustomed ourselves to the dangers of living in a world where intimate activities that used to take place in a drawing room or in a mall and could only be observed are now recorded and monitored. So this is another reason I think that the example of Monica Lewinsky's emails and diaries are so important. Monica Lewinsky didn't mind that her friends knew that she had bought a copy of Nicholson Baker's Vox, a fine and eminently respectable but rather salacious book about phone sex, because her friends knew that she was more than just the sort of person who would read a racy book. But when all you know about Monica Lewinsky, or if all you know about me, is a book, the most recent book I've read, or the most recent music I've listened to, or a letter that I sent to a friend, you may misjudge me. You might allow part of my personality to stand for my whole identity. So to really know a person is a very difficult thing. It only happens with the smallest group of friends or family members or loved ones. But in the age of the internet, when so much of this intimate information is recorded and monitored, there's a great danger that information disclosed in one context will be taken out of context and exposed in another. This is really what Brandeis and Warren feared in the 1890s. Their wonderful classic article begins the notion that prurient information that used to be whispered in the closets is now being shouted from the rooftops. What upset Warren was a mild society item about his daughter's wedding. He'd put on a lavish breakfast party, and the Boston tabloids ran a little item about it. And he was appalled that, although the event wasn't salacious, that this society event, appropriate to disclose to his social equals, would be exposed to the world. So nowadays, all of us are like Mrs. Warren, the daughter, or like Monica Lewinsky. All of us run the risk of being judged out of context in precisely this way.
Your comments about the article led me to get my intrepid researcher, James Fabiano, to find it for me, and he found it, of course, on the web.
Excellent. Oh, that's very good.
And I'll be darned if I can find my copy of it now. But I had wanted to refer to it, and now I can't, because it was, as you say in your book, as you write in your book, such a, here it is, such an incredibly prescient notion that the individual shall have full protection in person and in property is a principle as old as the common law. But it has been found necessary from time to time to define anew the exact nature and extent of such protection. And then they go on to point out that then that was the time, and that was, what, 1890. And it would seem that it is time again, and I believe that that is the thrust of your magnificent study here, the unwanted gaze, because you're saying privacy has been destroyed. But Professor Rosen, there is something else that you're saying. You seem to be making the point that we, the people, have embraced this loss of privacy, rather than that there are those who can now steal it from us. And you really feel that way, that we're co-conspirators.
I hope I'm not that pessimistic. I mean a note of grim and chastened optimism, maybe, to emerge at the very end, because I do give examples of cases where political vigilance has actually protected privacy rather than being complicit in its destruction. We have the recent example of DoubleClick, the internet advertising broker that tried to match our online and offline browsing habits with our actual identity. And people became appalled. As long as the browsing habits were anonymous, people were happy to accept these electronic cookies. But as soon as it became clear that this internet broker was compiling East German-like dossiers on our online and offline behavior, there was a protest, the stock price plummeted, and under political pressure, DoubleClick had to back away. So this just reminds us that political vigilance actually can protect the surveillors and stop them in their tracks. And I mean in the book to trace the sad story of this legal, technological, and cultural shift, but to offer some constructive suggestions, too, I hope, for trying to resist it.
May I say that your optimism does not shine through?
Perhaps just the glimmer of the gaze coming through the pages would be all. One doesn't want to be too celebratory in these
In
matters.
making Louis de Brandeis your hero,
yes,
and in referring to the Warren and Brandeis article in the Harvard Law Review, you would seem to be indicating that there needs to be a strong judicial stand. Do you see that coming now?
I think law is important, but it may not save us in the end. The reason the Brandeis article is so central to the book is that it led me indirectly to the title, The Unwanted Gaze. Where does this come from? Brandeis and Warren were struggling with the fact that American law has traditionally been hesitant to protect offenses against honor or offenses against dignity. Instead, as we discussed earlier, it's really been notions of private property that have protected us from invasions of privacy. This was effective in a pre-cyberspace world, but as Brandeis himself recognized in the celebrated case from the 1920s involving wiretapping, where the Supreme Court held that it was not a search to put a wiretap under someone's house. In his heroic dissent, Brandeis looked forward to the age of cyberspace, said ways may someday be developed where you can remove papers from desk drawers without breaking into the home. We need to translate the Fourth Amendment to protect this dignitary interest in privacy in a world where privacy invasions are no longer based in private property. It's really an excess of regulation that's led to inadvertent violations of privacy that are greater than those that the law seeks to remedy. One part of my book examines the inadvertent expansion of, for example, sexual harassment law, which has given employers a legal incentive to monitor private email and internet browsing. The most recent study by the American Management Association suggests that a half of all large employers now monitor internet use. And partly this is a consequence of the ambiguities of the Supreme Court's hostile environment test for sexual harassment, which often makes the illegality of speech turn on the subjective perception of the listener. So because any employee might find speech hostile or offensive, there's an incentive to overregulate. We're back to Brandeis and Warren again. Our law has no vocabulary for punishing dignitary offenses, and the inadvertent and well-intentioned effect to do so through harassment law. Think of all the collateral violations of privacy it spawned, not only that of Paula Jones bringing her suit, but Monica Lewinsky, who was forced to describe her own consensual sexual activities under oath. It was such a violation. She said, why should Paula Jones's right to sue take precedence over my right to privacy? And this, I think, confirms my classically liberal intuition that the state cannot save us from being misjudged and insulted and viewed out of context. Society is an orgy of judgments and misjudgments, and as long as there aren't tangible employment consequences, often it might be better to favor social rather than legal regulation.